welcome. In this on-demand video, OJM Group Partner Carole Foos, CPA, provides an overview of tax legislation that took effect in 2023 and its significant impact on retirement plans for physicians and medical practices. If you have more questions or want to learn how to incorporate tax planning into your financial strategy, click the link below to schedule a complimentary one-on-one consultation with one of our experienced team members.
Hi, this is Carole Foos, CPA, a partner at OJM Group. Thanks for joining me today. I want to talk to you for a few minutes about the Consolidated Appropriations Act of 2023 and how it's going to affect your retirement plans and your contributions into those retirement plans moving forward. There were a lot of changes in this law, and it was passed at the end of December 2022. One of the biggest changes that you might have heard about is the increased age for beginning to take required minimum distributions. Now, as you know, it used to be that you had to start taking required minimum distributions at age 70 and a half. The Secure Act, the first one passed a couple of years ago, changed that age to 72. This new law increases the age for beginning to take required minimum distributions to age 73 for those of you who were born between 1951 and 1959, and increases it to age 75 for those born in 1960 or later. So for those of you who don't really need to take required minimum distributions from your plan in order to help with your living expenses, this is a big benefit in terms of reducing taxable income that you'll have to take out in the future. In addition to that, it does gives you some more time if you choose to make Roth conversions to the plans or do some other planning that will help. Now, what it did not change is that you can still begin to take a qualified charitable distribution from your plan once you're age 70 and a half. That's going to be where you take a distribution from the plan and it goes directly as a contribution to a charitable organization. So you can still do that at age 70 and a half. Another significant change is the penalty if you did not take a proper required minimum distribution when you needed to, or the amount you needed to. Used to be a 50% penalty of the distribution that you didn't take. That penalty has dropped to 25% under this new law. And in addition, this is a big change. It eliminates required minimum distributions if you have a Roth 401k or a Roth 403b plan. Now that will be effective in 2024. And this means that Roth 401ks and Roth 403bs will basically be treated the same as a Roth IRA in terms of not having a required minimum distribution. So that's going to be important as well as you're planning. Another significant item in the Consolidated Appropriations Act is a new ability to transfer a 529 account balance to a Roth IRA. Now, this does come with a lot of restrictions and caveats, but it can be beneficial for those of you who have funded a plan, for a child or a grandchild, and all of the monies weren't used for education. So in order to make this transfer, and keep in mind this begins in 2024, the Roth account that you're transferring the money into must be in the name of the 529 plan beneficiary. In addition to that, the 529 plan must have been maintained for at least 15 years. So for many of you, that won't be a problem if you started a 529 plan, perhaps when your children were born or when they were younger. Now they're out of college and they haven't used a plan. As long as it's been in place 15 years, you're in good shape. You cannot transfer contributions that were made within the last 5 years or the earnings from those previous 5 years' contributions. Now, what they're trying to eliminate there is people just putting money into the 529 plan in order to then transfer it to a Roth IRA. The lifetime maximum that you can transfer is $35,000. So, if you've still got 50, 60, $100,000 in that 529 plan, you won't be able to transfer it all. Also, the annual limit for transferring is going to be the same as the IRA contribution limit for that year. So as an example, if this year's contribution limit for an IRA is $6,500, and if this law were in effect this year, you could only take $65,000 out of that 529 plan, transfer it to a Roth IRA in the name of the 529 beneficiary. You can do that again next year and the following year until you get up to that $35,000 limit. Now, keep in mind, in order for that beneficiary to make a Roth IRA contribution into his or her account, he or she will have to have some earned income to contribute. So you want, if it's your child, right, you want them to have some compensation income in the year that you are contributing this or making the transfer. What is still to be determined is whether you can change the beneficiary on that 529 plan. You can change a beneficiary, but does that restart that 15-year period for the 529 plan having been maintained? That's not been made clear as of yet with this law, but that might be an option for some of you who, again, have those 529 balances, want to get them out of the 529 plan. Maybe there's not a sibling to transfer it to, not a grandchild to transfer it to. This Roth IRA option could make sense for you. Catch-up contributions also are seeing a significant change. This provision also will take effect in 2024. What's happening here is they're saying that if an employee made more than $145,000 of W-2 income in the previous year from the employer sponsoring the plan, then that employee's catch-up contribution has to be to a Roth account. Now, this applies to 401k plans, 403b plans, and governmental 457b plans. It does not apply to an IRA catch-up, including to a simple IRA. So if I'm an owner employee, I made W-2 income of greater than $145,000 in 2023, then in 2024, my catch-up contribution to my 401k plan has to go into a Roth account. Couple of things to think about on this. One, that means you're going to be taxed on that catch-up contribution. The contribution will be after-tax dollars, okay? This also, the thinking is it may not apply if there's a change in jobs. So if you are an employee or you have an employee who you worked for a different employer in 2023, you changed jobs in 2024, even though you made $300,000 at that previous employer's in 2023, it seems you would still be able to make a regular catch-up contribution to a regular 401k in 2024. Also, this is a big item. If your plan has employees who would be subject to these limits, so employees who made greater than $145,000 in the previous year, and your plan does not have a Roth option, it's going to take away the ability for any employees to make catch-up contributions. So I think one thing to consider if you're the employer is speaking to your, TPA, you might want to change your plan documents and add that Roth option, if this is going to apply to you as an employer, or if you're an employee, asking your employer about that. Some of the miscellaneous provisions that came into effect with this plan. First, and I feel like this is a big one, employer non-forfeitable matching and non-elective contributions can now be made to Roth accounts. Now, again, I think this is a big deal. It's in the past, only a salary deferral contribution could be made to a Roth. Any employer match, employer QNET contribution had to be made to a traditional account. So that's gone away. Those contributions can be made to Roth accounts as long as the contributions are non-forfeitable. So if there's a vesting option, they can't be made to a Roth. Simple IRA and SEP IRA contributions can also be made to Roths, and that starts in 2023. And again, that employer match going into a Roth starts immediately. And then beginning in 2025, there will be an increased catch-up contribution amount for anyone turning 60, 61, 62, or 63 in a given year. That's going to apply to your 401ks, your 403bs, as well as simple IRAs. The new catch-up limits under this provision will be, if we're thinking about a qualified plan, so a 401k or a 403b, it's going to be the greater of 150% of the regular catch-up, or $10,000. So this year, the regular catch-up amount is $7,500. You could take 150% of that and add it to your catch-up, although, right, 7,500 times 150% is $11,250. So you'd be limited to the 10,000. Your simple limit is going to be 150% of the regular catch-up, or $5,000. So again, it's a way for older employees, older participants to really bump up those retirement plan savings, which was a major focus in this law. Some of the employer provisions that we're seeing in this law, which might affect many of you, beginning in 2024, if you have employees who are making student loan payments, those student loan payments will be treated as elective deferrals for the purpose of matching contributions. So what are they trying to do here? They're trying to help some of these younger employees who maybe are encumbered by large student loan payments, therefore don't have the disposable income to contribute to their 401k plans, sort of not be penalized so that they can still receive an employer match on those. Now, you can do this based on just an employee's certification of those student loan payments, and you must have the same vesting and matching rules for those who qualify for this as if it were just a normal employee deferral. So you can't change the vesting and matching rules for those who are making these student loan payments and will now be eligible. The law also has included a new starter 401k for businesses that don't currently offer retirement plans. This is also effective in 2024. These new starter 401k plans will include automatic enrollment of employees, and they will have contribution limits that are equal to IRA contribution limits, so less than a normal 401k contribution limit. In addition, new provision of this plan is that any new plans, newly established plans, must have automatic enrollment of employees. So that's new. Another new provision is that part-time employees will be able to participate in qualified plans if they are age 21 or have completed 12 months of service and have over 1,000 hours worked, or if they have completed 2 12-month periods of work of over 500 hours and are age 21. So those are just some things to talk about. Talk to your TPA about these provisions in case your plan documents need to be changed for this. We're seeing a lot more ability to contribute to Roths. So for those of you seeking out tax diversification and trying to build those 3 buckets of income, you've got some greater opportunities to do that. Some of you will be forced to make some Roth contributions via those catch-up contributions if you're highly compensated. And we want you to be aware of the planning opportunities for that, as well as being aware of the tax implications of that. So thanks for joining us today. We appreciate it.
OJM is a multidisciplinary wealth management firm. For nearly 2 decades, our firm has helped physicians across the U.S. reduce taxes, protect assets, and achieve their financial goals. OJM Group offers viewers a complimentary consultation where we can answer your questions to see if our firm might be a good fit for your situation. Simply click the button below to schedule your free consultation. We hope to speak with you soon. Thanks for watching.